Exactly. We're going to try to get the timing a little bit back on track, and I think we'll be able to do that. So we'll get started as soon as our distinguished panelists arrive. And we do have a very exciting panel for you today. This is a real superstar panel, so I'm going to keep my substantive role to a minimum, just trying to facilitate and keep it crisp and on track and hopefully clear as possible, because this is a complex area. I'm Chip Pitts. I'm the board chair of the Electronic Privacy Information Center. We've been existing for about 23 years, and as Jeff Chester said, work very closely with a lot of the privacy and surveillance community. We recently expanded our mission to not only embrace emerging privacy and civil liberties issues, but human rights issues generally. We expanded our mission statement last year in that regard to better reflect the enabling, the truly fundamental nature of the right of privacy and how it's connected to human rights generally, not just civil liberties in the narrow sense. You know, human rights like the right to personal development, which we heard the Special Rapporteur of the UN describe this morning, non-discrimination, all sorts of fundamental rights. I won't read the introductions to you. You have the bios in your program, so take a look at those. But let me just briefly say that we have Anna Spencer, who is the head of the both privacy and health practice, that intersection. She has both areas of expertise at Sidley and Austin as a real preeminent legal leader in this field. We have Aymeric Dupont from the EU Delegation, and he'll be giving us the EU perspective on the Privacy Shield and the data regulation in the EU that's going to be coming into place. We have Drew Mitnick from Access Now, Policy Counsel with Access Now, and then finally Andrea Matwyshyn, am I saying it right? Mm-hmm. Amazing, I remembered. Who is a professor of law at Northeastern. Each of these people has a variety of other truly eminent distinctions, so do take a look at the bios. But without further ado, let's get started. And I just want to say the topic is, will the EU Privacy Shield and data regulation affect the US? Spoiler alert, yes, it will. The more interesting questions, of course, are, you know, what's happening? Because it is a complex area with lots of acronyms, lots of legal complexities. We're going to try to simplify those for you a bit today. And then what should our stance be? You know, whether you're in the private sector, an individual, whether you're representing government or some multi-stakeholder initiative, what should we do to have the best public interest outcomes for the benefit of everyone? We also, I do want to remind the panelists, we've agreed that we're going to be very strict on our timing deadlines. So we're going to each give them literally 3 or 4 or 5 minutes max to give their perspective on the issues. And then we'll be sure to have some more rich time for questions and answers, because we really want to address your concerns. So if you have a question, keep it in mind. And if we don't answer it, we'll be sure to try to get as many of those answered as possible. So without further ado, let me turn it over to Anna Spencer from Sidley and Austin.
Okay, good afternoon, everybody. Very happy to be here. Before I launch into the Privacy Shield, I just want to set the stage a little bit and give you some background. I'm sure most of you are familiar with what's going on with respect to cross-border transfers, but to the extent you're not, I'm going to touch on very quickly the background. So, of course, the U.S. and the EU have different approaches to data privacy and security, and you've heard a lot about that at the conference so far. This is oversimplifying a bit, but the U.S. is characterized by a sectoral enforcement-based approach. Enforcement is very vigorous in the United States, notwithstanding the sectoral approach. And then it's also, there's a backstop, if you will, with FTC enforcement against a variety of companies, including internet-based companies, where they engage in unfair, deceptive trade practices, and that's vigorous as well. It is also true that the U.S. approach is generally considered more accommodating to business. And whether you like that or not, the fact is that that's one reason why our economy is generally a strong one. Contrast that with the EU. The EU is characterized by, as our prior panelists said, a comprehensive approach that governs the processing of personal information across all sectors of the EU economy. And it's also true that in the EU recognizes privacy as a fundamental right. The U.S. also has fundamental rights built into the Bill of Rights, so there are elements of individual rights that influence U.S. privacy law as well. These differences are due in part, I think, to historical differences. So, of course, there's the experience in the EU with Nazi Germany, where the government built dossiers on people that were targeted for government action, and then also the distinct legal traditions. In the United States, of course, we have a common law tradition where judges play an active role in shaping the law, whereas in the EU, they have a civil law tradition, and that's characterized, and there's a focus on a long, detailed codification of law. Important to our discussion today is that the EU law prohibits transfer of data, personal data on individuals in the EU to jurisdictions that are not deemed by the European Commission to provide an adequate level of protection. So a small list of countries like the Isle of Man and Canada, Argentina have been deemed to provide an adequate level of protection. Oddly, I think, the U.S. has not been deemed adequate yet. Therefore, because of this restriction under EU law, we have to have a transfer mechanism for companies that operate in the EU to transfer personal information from the EU to the U.S. in order to legitimize that transfer. Historically, we had what's called the EU-US Safe Harbor, where companies in the U.S. would self-certify to certain fair information practice principles. In October of last year, as many of you know, there was this bombshell decision by the European Court of Justice that invalidated the EU-US Safe Harbor framework that was relied upon by over 4,000 companies to transfer data from the EU to the U.S. And it declared, essentially, the court declared that a decision approving such a framework requires a finding that the level of protection of fundamental rights and freedoms in the laws of the country to where the data is transferred has to be essentially equivalent to the guarantees that are enjoyed by EU citizens. So then on February 2nd of this year, the U.S. and EU regulators agreed to in principle, to the EU-U.S. Privacy Shield, which was to replace the Safe Harbor. But the framework has been criticized by the European Parliament, the Article 29 Working Party, which is a group of data protection authorities that have the authority to enforce EU privacy laws. And also recently, the European Data Protection Supervisor, they have criticized the Privacy Shield as being inadequate to protect the data of EU citizens from what they call mass indiscriminate surveillance by the national security apparatus in the United States. So whether the European Commission will ultimately approve the Privacy Shield, this alternative to the Safe Harbor, is very much uncertain. To further complicate matters now, other data transfer mechanisms are being questioned. So very recently, the Irish DPA announced her intention to apply to the Irish High Court to determine the validity of what's called model contracts or standard contractual clauses. That's another mechanism that companies use to transfer data from the EU to other countries where the Commission has not determined them to offer an adequate level of protection. So that's another fly in the ointment. And then, all of this may sound intellectually interesting, but not necessarily impactful until you consider the fact that just this week, German DPA penalized 3 international companies for allegedly unlawfully transferring data from the EU to the U.S. And not doing enough in this with respect to coming up and legitimizing the transfers of data. So as of today, we have what I would call to be a fast approaching train wreck for international data transfers from the EU to the U.S. So we have the invalidation of the Safe Harbor, a Privacy Shield that has not been approved. We have questions about the validity of model contracts. And we have penalties being issued by German DPAs for failing to do enough with respect to data transfers. So this is a bit of a mess, and it only seems to be getting worse. So there has to be a lot of work done, it appears, between the U.S. and EU negotiators to figure out fast come to resolution of these issues. Otherwise, we're looking at potential impacts to both economies, neither of which are particularly doing that well. So that's the background. And I guess my 5 minutes are probably over.
That was a terrific and admirably concise overview.
Okay.
Thank you,
Thank you.
Anna. Monsieur Dupont, it's up to you to say, how is the EU going to get its act together and clean up this mess that you referred to?
Thank you. First of all, I'd like to start Patient Privacy International for their kind invitation to come today. I think it's a long time since the EU has not been present here, so I'm very happy to be here today. I would like to start in the same way as my colleague on the right by setting a bit the scene on what we understand by data protection and health data protection in the EU, and then moving on to international transfers of data to try to give our perspective on the situation. Data protection in the EU, privacy are fundamental rights, and there are clear historical reasons for that. Nazi Germany was mentioned, but we should not forget that in 2004 we admitted a number of countries from Eastern Europe who had lived also through a totalitarian past and who have very understandable conceptions on and perceptions on why their private life and their data should be protected, especially from access by the government. We also have extremely high public expectations in the EU to protect the data. I think this is something we certainly share with the US. I think 81% of European citizens say that they don't have control over their data. I mean, this is what they said a year ago in the Eurobarometer, which is a survey we do every year. Therefore, I mean, the right to data protection and to privacy are well enshrined in our legal instruments, in the European Convention on Human Rights, in our EU Charter of Fundamental Rights, Articles 7 and 8, as well as in secondary laws. And the trend, and that may not look good if you is for a more robust interpretation by the court of this fundamental right of privacy and data protection. If you look at the latest jurisprudence in the last 10 years, you will not see a limitation of this right, but rather a more extensive reading of what, and this is exactly what happened when the Court of Justice in October of last year decided to annul the Safe Harbor Agreement. Our data protection rules in the EU are based on the 1995 legislation, which probably needed some polishing with the entry into the digital age. So in 2012, the Commission decided to put forward a proposal for a data protection regulation, which would be a single law applying across the EU. And that's very important. That's very important for citizens because we have a lot of mobility, but that's of course very important for businesses as well, who can operate on a level playing field across the EU. We are very happy that it eventually got adopted after a bit more than 3 years of intense discussions, because that's a debate that we clearly have in the EU. And the final text was published in early May, and will start being implemented in 2 years from now. The principle of the GDPR is that citizens,
GDPR being
the General Data Protection Regulation, is that citizens should regain control of their personal information. Personal data is not a commodity. This is not how we see it in the EU. And on that basis, we have established principles which very much mirror the 1995 directive, principle of consent. And consent is not a pretty box. It's not inactivity. It's not conditionality. It's not if you want to get that, then you should consent to the 15 pages which come later. And the regulation does reinforce that principle. Principle of purpose limitation. You give the data to your general practitioner, to an hospital. Doesn't mean that you give it for marketing purposes, or at least if this happens, then you should be aware of, and you should be able also to withdraw your consent. Principle of transparency, what's going to happen to my data when I give all of that to you. Principle of data quality, being able to correct the data, of collecting what's really needed. Principle of retention, you only retain what's necessary, and the right of access. So I mean, lots of additional layers of rights which are very clear in the regulation, and again which will apply across the EU. to make it work, of course, we have established a very strong enforcement mechanism, which will certainly get boardroom attention with fines, which could reach up to 4% of the worldwide turnover. And then how does...
% of the worldwide turnover.
Yeah.
So for a company like Google, that could be billions of dollars.
I think there is a kind of ceiling of 20 million euro, which is already quite big. But I mean, it's much bigger than what we have for the time being. And with the intense lobbying activity which went around the GDPR, I can tell you that I think companies have understood the potential impact. Health data in the GDPR is also reinforced, more protected. It's considered sensitive data at the same level as genetic data, biometric data, and its processing is simply forbidden unless authorized on the basis of consent or vital interest, medical diagnosis, or because, for instance, you need that for the social healthcare system. So by doing this, by establishing this regulation, we really aim at restoring the trust of our citizens, of our users, of our data subjects into the way that the data is treated, and to give them access to new opportunities. And that's really the starting point. I mean, trust and of data transfers out of the EU. One of our main principles is that the level of protection should travel with the data. So as my counterpart was saying on the right, it's the transfer of data outside of the EU is prohibited unless authorized by a number of mechanisms. And one of them is actually the Privacy Shield, which is in formal terms an adequacy decision of the Commission. So it's an unilateral decision of the Commission. The text was published at the end of February. I invite you to read it. It's 148 pages. Lots of annexes, which are actually commitments from the US administration. So you will sign a letter of Secretary Pritzker, a letter of the ODNI, letter of the State Department, letter of the Department of Justice, explaining how, reinforcing how the US can certify that the level of protection, can help the Commission to certify that the level of protection is essentially equivalent to the one that we have in Europe. And we hope to be able to put Privacy Shield on track by the summer. So now the last bits are coming into pieces. Article 29 Working Party has given its opinion. The EDPS has given its opinion. The Parliament has given its opinion. We know that they were not necessarily completely happy with it. So now the Commission is working together with the US to adjust the adequacy decision and the annexes, and to release in the next weeks a final text for adoption.
Very good. Thank you again for your brevity. We really apologize for it, but we're also grateful for it. That was especially appreciated, given that you're speaking in a non-native language. So that's very much appreciated. Drew Mitnick, you're a lawyer with an NGO, Access Now, which looks at these issues on a global basis. What do you feel about the current status and content of where we are?
Yeah, thanks, Chip, and thanks to Patients' Privacy Rights for throwing this great event. I'm really honored to be here. So I think if the name of this panel was "Will the Privacy Shield impact the United States?" the question is kind of what hasn't changed under the Privacy Shield, or what won't change if it is enacted, because when the Court of Justice of the European Union struck down the previous agreement, part of the justification was that the companies that were transferring data were playing a role in U.S. surveillance practices, right? So, and you can imagine a couple ways that this would impact health privacy. Things like bulk metadata collection, in which you can paint a portrait of an individual's lives and see what types of health services they're getting. I think that's at least an option that's on the table, given the level of surveillance. And under the PRISM program, which is one of the programs that the Court of Justice kind of brought into question, the content of communications is subject to surveillance. And so you could imagine a conversation between a patient and their medical provider being implicated in the surveillance. And so one of the underlying problems is that the United States has failed to extend human rights protections to non-U.S. persons. And so in this instance, that's Europeans.
I hope we can debate that.
Yeah, sure. I'd love to, sure. But I mean, as a general policy, the U.S. hasn't recognized human rights generally applying extraterritorially. So even with maybe a few protections in place, we can at least say that the U.S. doesn't have a policy of extending human rights protections. And so I think one of the prerequisites for a truly effective new agreement would be surveillance reform that would bring things like the PRISM program into compliance with international standards. And I should also say that's not to excuse European practices, because there are a number of new laws and laws under consideration in the European Union that have expanded or are set to expand surveillance powers, and I think it's worth mentioning those as well. I think the other thing which was really highlighted very effectively in the last conversation was the failure to extend or to create a true data privacy baseline standard. Obviously, we know the flaws in HIPAA, but that really only captures a small portion of the problem. The agreement requires companies to self-certify that they're in compliance with certain principles under the new framework, but self-certification in itself is a problem, because I think the court recognized that in self-certifying, the companies weren't effectively protecting Europeans' privacy. And so the passage of a data protection law, I think, should also be a prerequisite to a new agreement. So some of the problems that still linger are those are the kind of the highlights, but issues are kind of the narrow redress proposed under the Privacy Shield, the continued lack of transparency. So I think that there needs to be kind of a more in-depth conversation about what happens with data when it's transferred between the EU and the US that hasn't happened in preparation for the Privacy Shield.
That's great. You actually finished a minute and a half ahead of time. So you have a chance, Anna, to question Drew on, and are you saying that there is full protection for foreigners' human rights by the U.S.?
No, I'm not saying that. What I am saying, what I submit that the test that was articulated by the Court of Justice was not whether the regimes are the same. The test is whether they are essentially equivalent in ensuring and respecting the human rights. So Sidley, I encourage everyone to go to datamatters.sidley.com. We published an essential equivalency report. It is a bear. It is several hundred pages long. But the good stuff, in my opinion, would be pages 121 through 131. We talk in detail and knowledgeably about the checks and balances, which are very detailed for U.S. surveillance in the United States. One has to remember that a lot has happened in the last 5 years on U.S. surveillance. So the Patriot Act, there have been updates to the Patriot Act. Bulk collection of telephone metadata under FISA has been terminated. There have been clarifications about the reach of ECPA to protect the data.
ECPA being the electronic communication.
Sorry, I can't help myself, but throw out an acronym. Extended to foreign nationals. So, there have been, what we detail in that report is, I think a lot of people like to criticize the United States for the overbreadth of their national surveillance, when in fact they have never even looked at or understand exactly what they're talking about. And this report details exactly what those checks and balances are, and I submit that they are essential, as the report concludes, and as the draft opinion from the European Commission concludes, that they are, this is an adequate level of protection.
If I could just very quickly, and then I really want to hear actually what Andrea has to say, but one of the things that the European Data Protection Authority said in analyzing the draft Privacy Shield is that it maintains a system of widespread surveillance of Europeans, or it enables that to continue. And so I actually agree that a lot of those reforms have been very positive steps, but for example, the metadata reform mostly impacts U.S. persons. And so the question is whether the U.S. has effectively extended those protections to Europeans. And I think a lot of the reforms have not gone to Europe. And I don't think that the core question, which is kind of like this, how the broad depth of the surveillance has not yet been limited.
Okay, perfect segue to Andrea, who has something to say about these issues.
Thanks so much to the organizers for inviting me. So as the resident academic on the panel, I will point out perhaps a few bigger picture questions and some trends that you've heard across the other panelists' comments, and briefly highlight a few of these issues and open it up to your questions. So the first point that I'd like to raise is perhaps a slightly broader historical context. So I started my own legal career in the 90s representing, as a corporate lawyer, technology startups and large multinationals who were trying to figure out the data directive. And it was all new and exciting back then. And so it was this new, back then, EU regulatory regime that triggered a higher level of engagement in many US companies with questions of data privacy and data security. And so having the EU lead in some aspects of the privacy conversation is certainly not a new development. There was also at that time in the late 90s a concern, as we are similarly hearing some echoes of concern now, about a fast approaching train wreck of the conflict of the two regimes of US sectoral specific and more commercially focused data aggregation and sharing and a contract-based model, and this dignitary interest-focused model that was coming from a specific and different historical context from the EU. We arrived, of course, at the safe harbor principles, and those safe harbor principles played out in ways that perhaps serve some lessons. So self-certification was a core element of those principles as well, and there was spotty compliance and self-certification, both with respect to engaging with the principles and with the accuracy of the self-certifications. And although there has been some enforcement historically with respect to these safe harbor principles, the vigorousness of this enforcement on the US side is, I think, a bit of a question of the eye of the beholder. So in comparison to some regulators, enforcement activity, the level of enforcement is perhaps vigorous in the US, and the Federal Trade Commission, for example, certainly maximizes its available resources and seeks to enforce the privacy promises and security adequacy of companies in the States. But of course, the reality is that agencies are all constrained by the extent of their financial limitations and their staff. So I think that many privacy advocates would certainly view the level of enforcement to be nowhere near as vigorous as they'd like to see. So these are some of the backdrops that brought us into today's conversation. And indeed, the Max Schrems case and the Snowden revelations are underpinning the mindset of both the, I think, European side of this conversation and the US side of this conversation. And they are, of course, core to the trust building that is the fundamental underpinning of any kind of information relationship. The internet is driven entirely by trust. If people don't trust the data exchanges, then we will not have the robust information economy that we have come to rely on. And so it's with that notion of social trust building as the core of the goals of data governance that we're talking about here. I'd like to inject a bit of a technological wrinkle and a technology reality that particularly when we talk about self-certification obligations, we don't always consider the farthest reaches of the technologies that we're talking about. It is, for better or worse, I think, a fundamental principle of the implementation and deployment and repurposing of our technology systems, that the capabilities that are built into the systems that we see today will be used in all cases to their maximum ability and in repurposed ways that will reach further into innovative / invasive, methods of data collection and aggregation and redirecting for various purposes, whether that's private sector marketing or law enforcement. And so keeping a sense of the reality of the technology marketplaces and the capabilities of our systems as some of the benchmarks in our conversation around the framing of privacy and security discourse when we're thinking through, in particular, the definitions that have been raised as perhaps needing additional specifications in the Privacy Shield. I think that the definitional precision here is indeed a key element to watch for the evolution of. And the last point that I'll raise is the again, a broader context point about, for example, the umbrella agreement that was signed on the 2nd of June between the US and the EU on sharing of personal data for law enforcement purposes, which has not yet been approved by the European Parliament, but it raises some of the same social and legal questions about information sharing of EU citizens and the availability of reciprocal recourse in both governmental structures, and to what extent that is tied into our broader notions of the essential equivalence that is the core of the data protection regimes that we've had in the past with the data directive and the ones that we'll have in the future under the Privacy Shield. And I'll stop there.
Excellent points. We've covered a lot, and we do have some time for questions. So let's go right to it. Adrian from Patient Privacy Rights. And please do identify yourself if I don't do so.
I want to jump directly to the GDPR and how health data is, you mentioned it in passing. What I'm saying is different within the GDPR, particularly what kind of exclusions it provides for healthcare in the treatment sense, for example. And if we could get clarity on how, we heard a lot about HIPAA and the issues with it and the restricted things. I'd like to understand in the GDPR context how you're handling this issue of treatment-related exemptions to the kind of strong protections that you otherwise promote.
Who wants to take that, I guess? You want to start with the European?
Well, I can try my best because I have a much broader portfolio in our embassy here, but I think our baseline is that the principles which apply across the board within the GDPR are simply reinforced in the case of sensitive data. So the same obligations would apply, but let's say in a much more stricter fashion, keeping an eye at the potential impact of what can happen in case, for example, of a data breach, or when the consent of the patient is not respected, or when the processing goes beyond what has been originally agreed. So, my perception is that we have broadened the scope of health data. You have a long definition of what can be considered health data. In the GDPR, which actually makes it, forces a number of ways to interpret it in a broader sense.
I pulled up a description of the GDPR from a health perspective, and my impression was that it gave very broad exemption for treatment uses of data. And that's specifically what I'm asking about is there a broad exemption for life-saving measures, for example, or what here we would call break the glass and things like that within this context, or am I just misguided the way I read the GDPR?
No, there are exemptions in case of life and death, for instance, or it can also be for, let's say, public safety reasons as well. You have broad exemptions affecting health data. In that case, if the person is not able to give it his consent, but if there is a life and death reason to access the data or to process the data, then you wouldn't need the consent of the person, if that answers your question.
Since this is the topic of the Health Summit, do any of the other panelists want to elaborate in any way on that specific subtopic? No? Okay. I mean, the bottom line, as I see it, is that the GDPR, the General Data Protection Regulation, is really sort of the gold standard in the world today. And so I think that it was a product of negotiation and compromise, but the treatment of health data and data in general is actually pretty good given the constellations of interest that were involved. Yes, ma'am.
So I agree with you. I believe the GDPR is the gold standard, and whether it's that's the dealing with the Privacy Shield or thinking about TTIP, the Transatlantic Trade and Investment Partnership, why is it instead that we are not raising the bar in the United States to meet what Europe is doing? And maybe my question is best addressed to you, because to me, I think that would solve the problem.
To me? Okay.
I think it was pointing to
Sure.
you, Anna. Yeah.
Sure. The question is why the United States won't adopt a European perspective, code for code, line by line. So in the United States, as I said, to cut to the chase, we are more accommodating of business. That's not always a bad thing in my view. So for example, not to say that improvements can't be made. I'm not suggesting that U.S. law is perfect. I'm not suggesting that maybe an extension of HIPAA to mobile applications might not make sense, or that various laws should not be enacted. Not saying that improvements can't be made. I suspect that I feel that there should be. However, I, for one, do not think that adopting the European model in toto here in the United States makes sense. So, for example, under HIPAA, it is perfectly permissible for pharmacies to send out refill reminders to individuals, people like my father, who appreciates refill reminders, and he does not, and the pharmacy does not need to get consent for that. In Europe, consent would be required for that. That is both accommodating to business, and in my opinion, it furthers individual interest to get information on medications and is helpful. To burden things with consent always leads to a lower amount of processing, and people not always getting the processing of information is much more limited. So I for one would not support that. Do not think it makes sense, and would impact business in ways that would be bad for the United States economy.
Okay, for those of you who weren't able to hear it this morning, the keynote by Joe Kanatachi, the UN Special Rapporteur on Privacy, actually touched a little bit on these issues as well, and I believe he has a comment.
Yeah, I actually have. Can you hear me?
Yeah.
That's great. I actually have 3 comments, if that's fine.
You bet.
The first one is actually dealing with some of the things which have not been mentioned, because when we're discussing, and the first thing I'm going to deal with is Privacy Shield, right? It is perfectly true that the United States has made enormous steps forward over the past 5 years, right? And in fact, it is also true that when it comes, for example, for oversight of surveillance, many EU countries have got to catch up with the United States, right? And as part of my work as UN Special Rapporteur, I'm trying to make that happen. Don't get me wrong. I'm not saying that the United States has got it perfectly right, right? But what I am saying is that the United States, in some areas, has a more robust oversight mechanism. That's the first thing I'd like to say. The second thing I'd like to say is that the fact that the United States has improved does not mean that it has adequacy, right? So let's make sure that we don't skirt around issues, because what the court said, and we need to go exactly to what the court said, and I'm going to read out what the court said. The court said as follows: it is clear from the express wording of Article 25.6 of Article 95 of Directive 95/46 that it is the legal order of the third country covered by the Commission decision that must ensure an adequate level of protection. And the report mentioned by the lady, especially pages 21, 121, etc., is very good in the sense that it indicates how in many cases the United States meets or indeed exceeds certain US levels. But is that the same as saying that the United States has a level of adequacy? And the answer clearly and plainly is no. And most first-year law students would be able to say that, and I'm going to explain why. Because what it says is that essentially it must be that, and I'm going to read this clearly from the court because the court was quite clear on this. It said that it's the national provisions and the international obligations of the country. And with all due respect, just speaking as a lawyer, I'm not speaking as UN Special Rapporteur, objectively it can be shown that the national provisions inside the United States and the international obligations of the United States do not meet the adequacy provisions. So that is something which has got to be tackled. Frankly, and I'm expressing a personal opinion here, I think that the values are not so far apart. Frankly, I'm not saying that the United States should adopt EU, and to be more precise, these are not EU, these are European principles which have been there for a very long time, en bloc. But I'd like to repeat the argument just for the sake of those people who weren't here this morning, that the United States might want to ask itself why. Almost nobody has copied the United States model around the world, right? And it's possibly because, and this is where one of the few points where I'm going to disagree with the
No,
lady.
it's actually worse in certain, as you said, it
No.
is certainly, it is worse in many EU member states.
No, it's not worse.
So,
What I would like to
okay, well, I can give you an example of one. So
let's-
let's talk about specifics.
Let's talk about specifics.
Yeah,
so
let's
since
do.
we're going to talk about specifics, right? We have.
I'm going to give you both 2 minutes on
Okay.
this.
Okay.
1 minute each. so.
I'd like, yes. And this is, in fact, this was the third comment where I'd like to disagree very respectfully with the lady. When we come to what countries can do and cannot do, the argument that I was proposing is, does the United States, and this is where I contest that it's more expensive for business, right? I actually put the argument to you that the business model of privacy protection in the United States is extraordinarily expensive. It's much more expensive for business, and the worst part of it, it's expensive and confusing for the citizen who should be protected. And that is why I think that without in the least needing to look at the European model, don't look at the European model if you don't want to. You know, a good idea is a good idea, as a good idea, but if you don't want to have good ideas from there, it's not a problem. What I'm suggesting is just look at the United States, look at data flows inside the United States, and ask yourself, is this really the most sensible way to do things? Is this the most cost-effective way to do things? And could we actually reduce costs? And the very final point when it comes to consent, because this is key to health data, right? And the lady mentioned the example of the prescription of her father. And having had a father who had to go through a lot of prescriptions, can I say that one of the things that we need to explore, especially in the area of big data and the area of medical data, is the extent to which we now have the technology to give the citizen consent, meaningful consent. And what I'm saying is, should we not investigate that technology, not only to give consent to the doctor or to the pharmacist, but also to the citizen?
Okay,
Right.
thank you so much, Joe.
So,
And let's have both Anna and then Andrea wants to reply.
okay, so what I didn't hear, what I heard was a legal conclusion that it's inadequate. What I continue to not hear from various authorities is why. So if you look at, again, a legal analysis, there needs to be backup for why it's inadequate. So when you look at what the report that we produced, for example, FISA prohibits surveillance for unlawful discrimination or suppression of dissent, and only Belgium within the EU has a comparable provision. In addition, under a 2014 presidential order, which is binding on the federal government, The nation's intelligence agencies are directed that all persons shall be treated with dignity and respect regardless of their nationality. So to your point earlier that the changes that have been made do not extend to foreign nationals, they do. Or wherever they may reside, and all persons have legitimate privacy interests in the handling of their personal information. So what I don't hear from people, again, when they talk about the fact that the United States, even with the changes that have been made with respect to national surveillance for national security, is specifically addressing why the Privacy and Civil Liberties Oversight Board, which exists as a check and balance against overreach by the government, why all of these changes that have been made, including the presidential order that I just mentioned, are not adequate. That is what I don't hear. People talk in broad, conclusory terms about how the order in the United States for national security is inadequate, is not protective enough. Really, what they should be talking about, whether it's essentially equivalent. Yes, the approaches are different, but there is a difference of legal opinion, and I submit not enough discussion and addressing of the specific checks and balances of the United States and why they are inadequate.
Okay, let's go for 30 seconds each to Andrea, and then Drew has something to say on this as well.
So 2 quick points. The first is just to kind of redirect this not from a legal standpoint, but from a business standpoint. There are already examples of companies that are opting out of U.S. law in some ways and building plants in other countries that have more restrictive privacy laws because of other aspects of the legal regime that are not win-wins for them in terms of their business model. So this is just one legal regime that fits into a whole picture of a particular company's business model and technology rollout, and that's why I was highlighting the practical reality of the technology constraints. The second point that I'd like to raise is that I think with privacy conversations, it's important to remember that one person's notions of utility are very different from another. For example, one person may really appreciate the reminders from the pharmacy. I, on the other hand, absolutely would not want that because I would assume that my pharmacy's security systems are completely inadequate and it exposes my data to additional risk. If I wanted reminders, I would go hunt down, after thorough research, the most secure app available that shared my information least and have it locally stored and program it for myself. But these are choices that exist within a marketplace of many different technology models. And so the way that we determine consent exists within the context of these technology constructs as well as the legal constructs that we have in our respective societies.
Very good. Drew, and then Aymeric.
Yeah, I can be very brief. And so one area I think where the U.S. has demonstrated that it is inadequate is in limitations on surveillance. So if you look at things like Executive Order 12333, which enables surveillance outside of the U.S. on non-U.S. persons, there are essentially no limitations. If you look at the FISA programs, foreign intelligence is broadly defined such that nearly all information is subject to FISA, that is of non-U.S. persons. So there might be oversight that Europe doesn't have, but I think in the collection of Europeans' data, the U.S. is inadequate.
I just have to interject one little substantive point. I've tried not to, but on the limitation that Anna referred to, that only Belgium has the similar restriction that we have in FISA, that you can't collect information only to violate the First Amendment or to dissent. Well, it's never collected only to violate the First Amendment or repress dissent. There's always some other reason, and it doesn't even have to be a pretext. It can be a legitimate national security reason, for example. So, there are these complex issues, and I hope we get into the questions. We have a couple more questions. I hope we get into more of this idea that's emerged with Joe's comments and a couple of panelists about how a lot of companies are seeing protection of privacy and human rights consonant with their interests, how it is the win-win solution is possible. I believe you were here first, sir, and let's take both of these questions and then we'll let the panelists respond.
Okay. First, the reminder, as you put it, about your father's meds. They work one way. They usually include an automatic, we will refill and send you the refill. What doesn't work with that is that the information about changes in the meds are not sent back to the physician or the pharmacy doesn't deal with them. In other words, if your father's warfarin is reduced from 7 milligrams to 3 milligrams, there's no feedback loop from the pharmacy. And what happens is your father is now getting the 7 milligrams and the 3 milligrams and will probably die of a hemorrhage. That's built into the marketing model of keeping up the flow without the feedback of different changes in meds. Secondly, I'd point out that 26% of all hospital admissions for people over the age of 65, which is basically all hospital admissions, is for medication screw-ups. So it's non-trivial that we allow that and that we don't stop it. Also, of course, there are privacy issues. If you continue to get your medications for your STDs, your husband may find that amusing.
Through
or
your
not.
what was that acronym? I missed it. Oh, STDs, okay.
Yeah, or, pregnancy pills or whatever. Medication is some of the most intimate information we have. Thank you.
Yes, ma'am.
Actually, it sort of goes to what this gentleman said and what Mr. Dupont mentioned. Under the EU model, you talked about access being one of the fundamentals of that model. And we know that electronic health records have a lot of errors in them. Probably 30% of medication lists have errors in them from studies that have been done. But very often it's very difficult to get access to medical records in the United States, even if it is allegedly guaranteed under HIPAA. They give sanitized versions. There's not a real ability to correct those medical records. Does EU have a different model of how to access medical records and how they can be corrected?
Do you have time for 30 seconds each from the panelists? Okay.
Yeah, no, I'm just...
If you have any final comments or thoughts you'd like to make, either in response to these or generally?
I can respond to your question and make a comment on the right to access. We see the right of access as quasi absolute. So you own your personal data, so which means that you can turn and you can challenge. If your right to access is denied, you can challenge it with your data protection
Even
authority.
psychiatric records?
I guess so. I don't think there is a limit on that. If you hold the data, you are the owner, you are the data subject, you have full access. Very quick comment. We want a privacy shield which stands in court. There is absolutely no interest in the EU to build something which wouldn't resolve court scrutiny. And surveillance debate, has been at the core of the discussions, and not only in the last 6 months, but in the last 2 years. And this is what initiated the review of the safe harbor regime. So if we go with a privacy shield, as we presented 3-4 months ago, it's because we believe that we have sufficient guarantees by the US government on clear safeguards and transparency obligations, new mechanisms like the ombudsperson mechanism established in the State Department, and sufficient reforms. Of course, reforms can only be better. I'll take an example. The Judicial Redress Act, which was mentioned, is great.
Example, just because we're out of time.
Yeah, but it shows that it can move.
Comments that the other panelists have to make? I apologize to interrupt you. Are there any final responses or anything? All right, we're trying to help Deborah Peel get back on time.
No. Okay, we can stop now, but only if all of you promise to come back next year. Weren't they fantastic? Thank you very much. So now we have 3 breakout sessions, and the first one is called Privacy as a Fundamental Human Right. It's going to be in room 205, which is on the level where we get the box lunches. The next one is As Health Data Exchanges Grow, What Rights Do Patients Have? And and that's in room 201. And the third one is a panel called Health Privacy and the LGBTI Community. That will be in room 202. So you're going to have trouble picking, but pick one of them. They're great. And then we will see you back here after these sessions at 3:55 promptly for a very exciting session I know everyone's waiting for. Latanya, you can try to hide, but we see you. So that we're going to have the latest updates on the data map, and and there'll be some food that you can have right after the breakout sessions. So thank you very much.
It's nice meeting you.